I was muted.
All right, welcome people. We're starting to fill up the room here. Glad everybody could join us today. We've got quite a few folks, and we're starting right at 9:30 California time, but Steve Case is joining us from the East Coast, so it's his lunchtime. He's skipping lunch to join us today, and we appreciate it very much. So thank you very much to everyone for joining us.
Absolutely.
And I'm Charlie. I'm with Church Westward. We've got some really exciting non-COVID news that we're going to be talking about today. We were counting up the webinars and meetings that we've had lately. Bob, I think we did probably 6 HR webinars that were specifically related to COVID, yes?
At least 6, Charlie, and I've got to tell you, I'm very excited for 2 reasons. One, you just mentioned, it's great to be talking about a subject that's not COVID for a change. That's first and foremost. But just as importantly, as you know, through the HR boot camps over the last, certainly over the last year, and other webinars that we've been doing with Church West, is we've been talking about these upcoming cases from the Supreme Court. And one huge victory out of the 2 are very good, but the one in particular is a huge victory. So we're really excited to finally get to talk to everybody about it.
Well, hold on. Don't get too excited. Don't steal Steve's thunder.
Ready to
Come
go.
on. Yeah. So no, I appreciate it. This is great. So we've got a good crowd, a lot of people. We've got about 500 people that have registered today. I think that this is something that a lot of people are interested in. I had a call with somebody this morning, and they said, oh, well, it's been bad what's been going on with the Supreme Court. And I'm going, what are you talking about? This is some really great stuff. And so, again, I just appreciate everybody being here. Let me switch to the PowerPoint slide if I can real quick. And give me 1 second. Here we go. All right, everybody can see that. We're going to be sending this out to everybody afterwards. We're not going to really be answering questions as we go through. We'll save some, if we have some time at the end, we'll go through some questions as well. But I want to tell you, this is hot off the press. As Bob mentioned, we've been talking about this for, I think, at least a year. We had our HR boot camps in January when we were talking about AB 5. I don't know if anybody remembers AB 5. But it seems like so long ago. But we've been talking about some court cases that we were anticipating. I want to tell you what this is. This is it's an analysis of legal issues, court cases, anticipated legal trends towards the end as well. I'll tell you what it's not. It is not any political opinion. It's not we're not advocating for one position or another. We're just reporting on these things. So I just want to tell you, there's some social issues, and we'll address those a little bit as well. But again, this isn't legal advice. Talk to your attorney. Speaking of attorneys, we've got 3. We've got Steve here. We've got Sarah. We've got Bob. Steve is from Brotherhood Mutual. I'm sure many of you know Brotherhood Mutual as an insurance company, and also their legal assistance service. They have Brotherhood Legal Assistance, which is a great spot when you have those initial legal questions. I know Steve has seen a ton of these questions come in about the Supreme Court issues, religious decisions, faith-based decisions. Steve, I know you've got tremendous experience on that, and you speak on this nationally. Thank you very much for being here.
Sure.
Sarah from Daly and Heft. She works a lot with the ministries here in California, specifically on HR issues. And appreciate you being here. And many of you know Bob, and Bob is somebody that we really rely on for a lot of our more complex legal issues here in California. They're a great California resource, and I tell everybody, when you have that initial legal question, always go to Brotherhood for their legal assistance. It's great. And Steve, we appreciate that resource that you provide to all of us. Okay, Steve, what's at the core of this? Tell me.
Yeah, absolutely. Well, first of all, Charlie, again, just thanks for having the idea to put this on. I think it is a good reminder that there are other things going on in the world other than COVID-19 as well. And this year has been an important year with respect to some landmark cases coming out of the Supreme Court in ways never done before. And that's what we're hoping to dive into. And, just at the outset, it's not all doom and gloom. A lot of times when we talk about religious freedom and the church, a lot of times we go to a negative outlook. I think the Supreme Court has come down with some decisions that have solidified religious freedom in many ways, and that's what we'll be walking through. But at the core, like you said, Charlie, is this tension between the First and 14th Amendment. And we know that American society is changing, that culture is changing fairly rapidly. And what we see from a religious freedom perspective is this butting of heads of the First Amendment and the 14th Amendment. And it's important to understand, with the First Amendment, that is what provides us our freedom of speech, our freedom to exercise religion, freedom of association, to gather with people of like viewpoints, and also to have that freedom to not be interfered with by the government in the exercise of our religion. And then you have the 14th Amendment, which is the anti-discrimination amendment that requires due process of the law and equal protection under the law. And that's where a lot of the anti-discrimination provisions come from. And so what we've seen in recent years with the 14th Amendment is that same-sex marriage has been read into the 14th Amendment. That happened with the Obergefell decision in 2015. And so you have this butting of heads of this decision to allow people to live as they wish from an individual perspective. And then you have the First Amendment that allows religious institutions to exercise their beliefs, to share in their views. And there's this butting of heads that oftentimes is happening now, especially within the past 5 years. The other thing I'll say, and you mentioned it, Charlie, is that this webinar is not intended to take a position on any social issue. It just happens to be that a lot of the religious freedom cases that we're seeing over the last 5 years involve some pretty hot button social issues. So you're going to hear us today talk a lot about sexual orientation and gender identity issues, and I might say SOGI issues from time to time, and that just means sexual orientation, gender identity, because those tend to be the hot button issues where you have traditional conservative Christian values butting up against this 14th Amendment shift. And so that's what we're going to be diving into, how the Supreme Court has addressed those cases in the recent past.
Okay. All right. So talk to us about this, Steve. Or Sarah, sorry.
So kind of building on that, there's now some legislation, obviously, that we're all familiar with, the Civil Rights Act, which prohibits discrimination in employment based on race, color, religion, sex, or national origin. Then we also have the other pieces of legislation, such as the Americans with Disability Act and the Age Discrimination in Employment Act that prohibit discrimination on the basis of age, anyone over 40, or 40 and over. Not anyone on this panel is covered by that probably though, right? And then the Americans with Disability Act to prevent discrimination on disabilities. And so what our focus then will be is how the Title VII Civil Rights Act exemption comes into play, and we'll get into that a little bit further on. But those are kind of the primary legislations that we're all familiar with, the statutes that we're familiar with that focus on preventing discrimination in the employment setting.
So, Bob, what are some of the unique things here in California?
California is a little bit unique in a couple of aspects relevant to our discussion here today. First and foremost, California law with regard to discrimination is much broader. It covers a whole bunch of additional areas that The federal law, the Title VII law that Sarah just read, does not include, such as sexual orientation and or gender identity. So California anti-discrimination laws are much broader than the federal law. However, under California law, it's the Fair Employment and Housing that lays out these different anti-discrimination laws. The Fair Employment and Housing Act specifically applies to employers with regard to the employment aspect of it. But when we look at the Fair Employment and Housing Act and look at the sections of it that deal with discrimination based on race, gender, religion, national origin, sexual orientation, gender identity, you drop down a few paragraphs and it says, for purposes of this section, an employer is not a religious association. And they use the term association because a religious organization may be a corporation, it may be an unincorporated organization. So California's anti-discrimination laws with regard to employment are much broader than the federal laws, but with respect to our clients that are religious organizations, they're immediately exempt from it because by definition, they're not an employer. So that,
quick question.
when we look at these cases, we're looking at the federal law. That's going to be the thing that is most important with regard to discrimination in California. Yes, Charlie. Okay.
We get a lot of people that say, hey, from churches that just say, no, we're a church, we're exempt from that. No, we're exempt from that. Do you think that this is where a lot of this comes from?
A lot of the times, the clients that we deal with think that they're exempt from a variety of different things simply because they may have read something on the internet and the information isn't always accurate. However, a lot of, at least, the churches that we deal with that have participated over the past 4 or 5 years in your HR boot camps and those kinds of things now are aware much more than they have been several years back that these discrimination laws or anti-discrimination laws in California don't apply to them. But as you well know, oftentimes, and I'm sure Brotherhood is very much aware of this, oftentimes when we get a new lawsuit against a religious employer, it is not uncommon at all for them to allege that the employer, the religious employer, has violated the Fair Employment and Housing Act, because the attorneys that deal with employment cases rarely get involved in suing religious organizations, and they're not aware of the exception. So the first thing that we do on a complaint like that is to try to knock out that part of the case, because you've reduced substantially then our client's exposure to liability. And then we're only dealing with the Title VII issues. And then we look at whether the exception that Sarah just mentioned under Title VII might be applicable, in which case we can try to get our client out of the case entirely.
Yeah, I got to just add to that, Bob, because, one of the things I always say is anyone can sue anybody at any time for anything, whether it's sound law or not. And we see that all the time where there's a kitchen sink approach of every type of employment law or anything else being thrown into a complaint. So it's certainly what we talk about today, the state of the law does not in and of itself protect the ministry from being sued. But that's hopefully what we're going to also try to help with is providing some sound principles and practices that can hopefully put you in a safer position.
Yeah, Steve, I couldn't possibly agree with you more. At least on a weekly, if not multiple times a week, I will have a client ask, well, can we get sued for this? Can we get sued for that? And I tell them, sure, just what you said, you can get sued for anything. Any one of us can go down to the courthouse today, file a lawsuit against anybody we want. The issue really is whether it has any merit or not. And as you just indicated, the purposes of this discussion here today is to help our clients, help religious employers be in a position that if they do get these kinds of cases, that we're in the best possible position that we can be in to defend them.
Absolutely.
So let's talk a little bit more about the religious exemption for Title VII. So Sarah.
That religious exemption gives religious institutions the ability to give employment preference to members of their own religion. And part of that is that they need to set forth that those employees are going to be hired in furtherance of the church's religious activities. The purpose and character are primarily religious. And this not only applies in religion settings, though. That case you see there on the PowerPoint, the Corporation of Presiding Bishop versus Amos, that exemption applied in a situation where it was a non-ministerial employee carrying out secular duties. In that case, it was some employees who were working at a facility that was open to the public. And the employee, after being employed there, failed to qualify with a certificate that they were kind of a member in good standing, so to speak, and entitled to go to the temple. And because they were no longer qualified, they were discharged from employment and brought suit. And the court held that that Title VII exemption upheld, and they were allowed to terminate their employee based upon that preference. So that preference is good for hiring, and it's also good for kind of maintaining your employees, and gives you the ability to terminate your employees if they are not within holding up the tenets of your ministry.
Okay.
Can I comment on?
So let's, of course, Bob.
Charlie, thanks. And Steve, chime in here too. I personally think this case, we refer to it as Amos, just because the defendant's name is easier to remember than the plaintiff's. But it's a Utah case. It's from Utah. It involved the Mormon Church. It was from 1987, so it's been around for a while. But it's one of my sort of favorite go-to cases for a couple of reasons. As Sarah just mentioned, it involved an employee who was not a minister or in a ministerial function. They were in a very secular function. But when the court looked at this, what they saw is the Mormon Church owned a big gymnasium. And for some reason, they had set up this gymnasium. It was open to the public. They made it clear in the establishment of this organization, which I think is very important, that this gymnasium was intended to advance the tenets of their theology. It was supposed to be a mission of their church. And when we look at the opinion that the Supreme Court wrote in this case, I think one of the most important things that they mentioned is that the mission of a church is not limited just to their services on Sunday, or direct services like that, similar to that, to the public or to members of the congregation. They indicated in there that the mission of the church can be very much community-based and very broad and spread out in its sort of what we sometimes refer to as an outreach program to the community. So it was an acknowledgement by the Supreme Court that the practice of theology is not limited to just what happens in services on Sunday, but rather the mission of the church in its community base was a very, very important thing. And then when they established that as the premise for the operation of this athletic facility, and then they're looking at this fellow that was hired as the building engineer, which really had no religious purpose at all. They still looked at it and said under the exception under Title VII that the religious institution can select people and employ people of their own faith. A lot of times when you just look at that exception, it sounds like it applies only to the hiring of employees, that you could hire somebody who is part of your own faith. Well, what happens downstream? What happens when that employee is no longer compliant with your faith? The text of Title VII doesn't seem to address that specifically. But in interpreting that in this particular case, the court said, no, employment of a employee of your same theology applies to the entire spectrum of employment, hiring, discipline, how they carry out their work, and even termination. And in this particular case, one of the requirements that the Mormon Church had for all of its employees is that they be a member in good standing. They had a particular requirement that this gentleman have what they call a temple recommend, and he never achieved that. He was supposed to have achieved that over time, so he was not meeting the theologic criteria of their organization, and they terminated him because of it. He was a secular, he did secular work. He was a facilities guy, a building engineer. And the court said that is permissible under Title VII. So I think this case, even though it's old, in relatively speaking, extremely applicable today, and it's very applicable to the cases the new ones that we're coming down on. What are your thoughts, Steve?
Yeah, just a few things to touch on, because you are exactly right. And it is very important that the Supreme Court kind of zoned in on the purpose of the ministry, that it's not just about what happens within the four walls of a church or what happens on a Sunday morning or whatever day it's meeting. It's about what's the purpose of the activity, right? And so one of the things that we always recommend is whatever type of activity, outreach activity, a ministry is planning. And that is, if you're allowing HOAs to use your facilities for meetings, if you're allowing your facilities to be used as a polling station, if that's allowed in California, I'm not sure. If you have a gymnasium or some other practice or activity that looks more secular in nature, one of the best things that a ministry can do is at the outset specifically state the why. Why are we doing this? How does this further our mission, our ministry? You think about opening up a coffee shop that's open to the public. A lot of churches do this nowadays. But the idea is you're getting people to step foot within your walls who may not ordinarily do so. And so that's huge. So always explain the why at the outset. The other thing I'll note is the EEOC, the Equal Employment Opportunity Commission, is well aware of this case. They are the body that's charged with enforcing Title VII. So they file a lot of litigation, they review a lot of complaints. And, following this case, they have made sure to note in their guidelines and their rules that the religious exemption applies to a religion test. If you are going to require somebody to follow your beliefs, to share in your beliefs, to be a member of your ministry, that's one thing. But in their guidelines, they say the religious exemption doesn't allow for sex discrimination or race discrimination or nationality or ethnicity, and then even jumping into age and disability and things like that. So it's important to understand that this religious exemption, since we're talking about scopes of to the extent that folks are exempted, the religious exemption is about making or having a policy that folks share in your beliefs or follow your beliefs. And that's what this exemption is really focused on.
And just to be clear, when we're talking about the types of organizations, we say church a lot or we say ministry a lot. But I mean, this is religious organizations. This is a Christian school. This is a Christian camp. This is a Christian college. This is a church, a synagogue, a mosque. It could be for any religious organization, correct?
Yep, absolutely.
All right, guys, I'm going to go because I know we're excited about this 33-year-old case, but I've got, and this is your favorite, Bob, and I'm going to have to rein things in just a little bit because we've got new recent ones, and I loved reading about these, and I've asked Steve to kind of give us the history of the Supreme Court decision number 1 and kind of the background of it, and there were other cases that were consolidated. So, sorry, go ahead.
Yeah, absolutely. So this is a Supreme Court case that came down earlier this year, Bostic v. Clayton County, Georgia. And what often happens with Supreme Court cases is they take several or multiple cases from the lower appellate level and they consolidate them together because they deal with the same issue of law or fact. And that's what happened here. Is there were 3 cases that got consolidated, and you'll hear me refer to them as Bostic, Altitude Express, and then Harris Funeral Homes. And I do want to spend some time, and I know we have a lot to cover, but these cases are so interesting, and even understanding the facts behind them is really important. So just starting with Bostic. Bostic was out of Georgia, and he was an employee of the county, and he was a child welfare advocate. Sometimes you hear about CASA, and he was a child welfare advocate and was very good at his job, was very successful at his job for a lot of years, even getting national recognition for the department in which he worked. And I want to say it was in January of 2013, he joined a gay softball league. So it was kind of an out softball league intended for homosexual individuals. And it became known by some of the leaders within the county. And he would attend some meetings, and he'd hear some disparaging comments about his lifestyle and everything else. And a few months later, he was actually notified that they were going to be doing an internal audit of his files, and that maybe there was some misappropriation of funds. And they did the internal audit, and then a month after that, he was terminated from his position. And they claimed that it was for like conduct not becoming an employee of the county. So they essentially alleged that there was some sort of misappropriation going on, and he alleged that this was really a pretext, and he was being terminated for coming out as gay because of the disparaging comments that he had heard from folks in leadership. And so he filed suit in a trial court level, federal trial court. And in those cases, it went all the way up through the appellate court and then ultimately to the Supreme Court. But in the trial case and the appellate case, the federal court in Georgia basically held that Title VII, which Sarah already talked about, it doesn't contemplate discrimination based on sexual orientation or gender identity. And because it doesn't contemplate sexual orientation discrimination, that doesn't amount to a violation of Title VII. And so his case was dismissed, and he continued to appeal it, and then all the way up to the Supreme Court. In Altitude Express, this one's an interesting one too, in that Zarda was a skydiving instructor for this company, Altitude Express, out of New York. And he, in his testimony, he said that he had a practice of whenever he was doing tandem skydiving, that is someone who's not well trained, the instructor gets strapped to the back of the beginner who's skydiving. And whenever he was going to be skydiving with a couple, he would make sure to tell them that he was gay, so that it would remove some of the uncomfortableness of him being strapped to a woman or a guy's wife or girlfriend. And there was one particular incident in 2010 where he let the skydivers know that he was gay or homosexual, and had shared that he was recently in a bad breakup, and got to talking about it. And after the skydiving session, the customers contacted the company and said, "Hey, we felt like it was really uncomfortable for us. It was inappropriate. We did not have a good time." And so later that day, Zarda was terminated, and management said that he was terminated because he was not giving the customers an enjoyable experience, and they received a complaint. Zarda filed suit and said, this is a pretext. Someone complained that I was gay, and now I'm being terminated. So I'm being terminated for being homosexual. And he filed suit for Title VII, and in New York, there were also state law claims, law anti-discrimination, and he filed suit for the federal Title VII and for the state law claims. And the district court, that's the trial court level, they actually dismissed his Title VII claims, the federal law, and they allowed his state law claims to proceed because New York contemplated sexual orientation discrimination as unlawful. But it actually went to a jury, and the jury decided in favor of Altitude Express, claiming that it was not a pretext and that he was lawfully terminated. He appealed that, and when it went up on appeal, the Second Circuit for the state of New York, the appellate court, reversed and said, no, Title VII, basically discrimination based on sexual orientation necessarily involves discrimination based on sex. And therefore, this is sex discrimination under Title VII, and ZARDA has a cognizable claim. And so that's why it got appealed further up to the Supreme Court. And then RG and GR Harris Funeral Homes, I'm sorry, I'm going into a lot of detail here, but this is another interesting one. I think the facts behind them actually matter. This is a case out of Michigan. And in this case, it was a longtime employee. All three of these dealt with longtime employees. In fact, the employee, his name was Anthony Stevens. He had started and he was promoted to, he was the funeral home director and head embalmer at this funeral home. And during the course of working there for like 6 years, Stevens battled with depression, loneliness, and a lot of different things, and he had sought counseling. And when he went to the counselor or psychiatrist, Stevens was diagnosed as having gender dysphoria, and Stevens was encouraged to live his life as a woman. And so Stevens made the hard decision to transition to being a woman. So Anthony Stevens became Amy Stevens, and the way that Amy let her employer know was that she was going out on vacation, and so she drafted a letter and she said, you know, I've been struggling with this for a while. I'm going to be going on vacation, and when I return, I'm going to present as a woman for the next year in order to start the process of actual transition. And before Amy Stevens could go on vacation, she was contacted and told by the owners of the funeral home that this just was not going to work out. And so Amy Stevens was terminated. And she alleged that she was discriminated based on her transgender status, alleging Title VII sex discrimination. And similar here at the district court level, that was dismissed, saying Title VII does not contemplate gender identity as a form of discrimination. And there were RFRA laws implicated and things of that nature as well, that took this all the way up to the Supreme Court eventually. And the question at the Supreme Court level was a very basic question. And that was, does sex discrimination as contemplated under Title VII necessarily include discrimination based on sexual orientation or gender identity? Those were the two questions. And the Supreme Court came down pretty emphatically on this one. I believe it was a 7-2 decision by the Supreme Court, even with some traditionally conservative justices siding with the more liberal justices for the majority. And you can read, as Charlie just put up on the screen, the majority, this is Justice Gorsuch, who you would say is a more traditional conservative justice. He specifically held an employer who fired an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. So sex plays a necessary and undistinguishable role in the decision, exactly what Title VII forbids. And so this was the first time that the Supreme Court of the United States officially recognized that sexual orientation and gender identity discrimination do constitute sex discrimination under Title VII. I've been talking quite a bit, but there's a few things that I'll mention, and then I'll get Bob and Sarah's input as well. And that is, this decision, in my opinion, was not that surprising, or it wasn't that drastic of a decision in that, one, many states already incorporated sexual orientation and gender identity into non-discrimination state laws. So it wasn't a surprise. Also, since I believe 2014 or 15, maybe even before then, the Equal Employment Opportunity Commission, that again is charged with interpreting Title VII, had been interpreting Title VII to include sexual orientation and gender identity discrimination. Now, the reason why there is some uproar over this case are a few reasons. One, you can see in the dissent that's in this PowerPoint written by Justice Alito, and that is, he says there's only one word for what the court has done today: legislation. The document that the court releases is in the form of a judicial opinion interpreting a statute, but that is deceptive. A more brazen abuse of our authority to interpret statutes is hard to recall. The court tries to convince readers that it is merely enforcing the term of the statute, but that is preposterous. One of the issues here is that Congress, on 2 separate occasions, had tried to modify Title VII through legislation to include sexual orientation and gender identity discrimination, and they failed both times. And so what Justice Alito and Justice Thomas were pointing out is that this really is a redefining of what the term sex means, especially as it was contemplated back in 1964 when Title VII was actually passed by Congress. And so that's what's got a lot of people up in arms. And then the second point that has a lot of people, or had a lot of people concerned, is what impact does this case have on religious institutions? And Justice Gorsuch dove into that a little bit, but he did not hold that religious institutions were protected. Basically, he said that's a decision for another day. That's a decision for a later case. But he did identify the religious exception under Title VII is something that may apply, and Sarah's already talked about why. And he also mentioned the ministerial exception, which we're going to dive into here in a little bit, that may apply. And he also mentions RFRA, the Religious Freedom Restoration Act, and that is there's a federal RFRA, and then there are several state laws, state RFRA laws as well. Actually, I'll just say that in Bostic, the court had actually said that RFRA applied to bar the claim. And what, in a lot of states, what RFRA does is it gives individuals, small businesses, the right to live according to their sincerely held beliefs and not have the government infringe upon that. And so the question was, is there a potential for RFRA application? But that wasn't the issue in Bostic. That was saved for another day. And that's why some folks were a little bit concerned, but we saw in some later cases that we're going to be talking about that religious institutions do indeed have some protections that fall out of Bostic.
So, Bob, what should we address, or what can we learn from these? Thank you very much, Steve. And I know you said, hey, I apologize, I'm digging into this. I think that a lot of people here are very interested in it, and and I think I appreciate the in-depth analysis of it.
Sure.
But Bob, what should we do on this? What do we learn, and how do we act from this point?
Well, I think there are a couple of things that we need to take away from this. Sarah started in the beginning of the discussion earlier about Title VII and the exception to employ people who believe in your same theology. That exception, as I see it, following the Bostic case, is critical at this point. Steve, would you agree with that?
Absolutely, absolutely, 100%.
Yeah, I think it's more critical than ever. And I think it's very important at this point that religious employers, assuming that they have a theology that is inconsistent with employing transgender people or gay people or whatever it is, assuming that is part of their theology, then I think that they need to solidify that so that, and Charlie, I should say that we look at this from an evidence-based standpoint. We're looking at a case when it comes in later on, and this church says, well, we terminated someone because they weren't acting consistently with our theology. They transitioned from female to male or whatever they did, and that's outside of the tenets of our theology. So then we then ask them, okay, where did you outline this in your theology? How is this documented? If we had to put this in front of a court, how would we have that documented? Is it in your hiring documents? Is it in your statement of faith that you give to new employees? Is it part of your discipline process? Do you discipline people or evaluate people periodically for their work performance? And in doing so, is there adherence to the tenets of your theology part of that discipline process? have you terminated other people in the past because their conduct was inconsistent with your theology? All documentation of that kind of a process is very important in defending a case like this, extremely important, so that we can establish what the theology is and why this person's particular behavior is outside of the theology, so that we are able to take advantage of the exception under Title VII if our theology is inconsistent with the more secular principles that were outlined in the Bostick case. I also want to point out too, a lot of people before this case came down assumed that it was going to be a slam dunk, because they assumed, I think, and wrongfully so in hindsight, they assumed that when an appellate court, in this case the Supreme Court, looks at a statute and is interpreting that statute, their job is to give deference to what the legislature intended at the time that they passed that particular law. So if the law is unclear or slightly ambiguous, and they are reviewing the black letter rules of the law, the black letter language of the law, they will try to give deference to what the legislature was trying to do. There is tons of documentation as to what we refer to the legislative intent. And we can go back and actually obtain copies of notes and all of these other things that the legislatures considered before they passed a particular law. And in that, sometimes it indicates what the intent was of the legislature in passing the law. So a lot of people assumed, because Title VII in its prohibition against sex discrimination was passed in 1964, that the intent of Congress at that point was sex meant male or female. And a lot of people assumed when the Supreme Court got this that they might very well say, look, we are looking at Title VII passed in 1964. In 1964, the intention of Congress would have been male or female. That's why in the dissent, as you pointed out, Justices Alito and Thomas said that the Supreme Court in this case was legislating. But the majority opinion in viewing it says that the intent was to make sure that somebody was not discriminated against or in a sub-position, a subordinate position in their employment based on their sex. And sex can mean a whole lot of things about a person. It's part of the identity of who this person is. So the Supreme Court went a much broader view than a lot of people would have expected given the age of the law.
Mm-hmm. Yeah, absolutely.
So with churches, what we should be doing right now, they need to review and update their governing documents. I think now is a really good time to review those, update those, and we'll be emailing out some resources following this webinar to address that. And then also their operational documents as well. We want to look at that for, state what the expectations are for your staff and for your volunteers. I know that's a big question a lot of people have. They say, well, do we have the same protections for volunteers? And I mean, the short answer to that is yes. Am I right?
Yes. I view volunteers as a volunteer as an unpaid employee. But with regard to Title VII, I don't think that's going to fly.
Right.
A person who is a volunteer under Title VII is not an unpaid employee. They are not an employee, period, under Title VII.
Yeah.
I tend to instruct clients to treat volunteers as unpaid employees so that they're holding them up to the same standards of behavior and conduct and all of these other things that they would expect of a paid employee, just to try to prevent some other problems, particularly when it comes to sexual misconduct and sexual harassment and those kinds of things. We want to make sure that volunteers are towing the line.
Yeah, I will say just one little caveat to that is I always think in terms of volunteers, TIERS, the tiers of volunteers, because when you work with some religious organizations, there are volunteers that they expect to basically know the beliefs, follow the beliefs to a T. They are considered teachers or leaders within the ministry. And so with them, you hold them to that same standard. But then I also know that there's a lot of religious organizations that they use volunteer positions as onboarding positions, whether it be traffic control, cleaning the facilities, packing bulletins or stuffing envelopes or anything like that. And in doing those things, a ministry might be willing to have someone who just started attending or is not, fully on board with the beliefs or anything like that, but they're not in a position of leadership either. So one of the things I always recommend is think through what are the onboarding volunteer positions and what are the volunteer positions where they are considered a leader, like a small group leader or someone who's working an information desk and they're speaking the beliefs of the church or ministry.
I agree with you, Steve. Part of the reason, too, that I spent so much time talking about the old Mormon case, the Amos case, earlier this morning is because that case dealt with exceptions to Title VII. And under the Bostic case, the exception in Title VII for religious employers has become vitally important. And so when we look back at Amos and we look at the evidence that Amos was available in that case that allowed that exception to take place, that is all that much more important when we look today following Bostic as to what evidence we need to have in place currently. So that's why I was kind of going back on that. It seemed like a bit earlier, I'm sure. But it really, in the Amos case, the Mormon Church had all kinds of documentation that the court relied on in establishing that the gymnasium had a religious purpose, that the employees were supposed to follow the tenets of their theology, that they had to meet these criteria throughout their employment. So those principles have now become much more important even today. And we want to make sure, following Bostic, that we have set out what those principles are. And that can be in employee manuals, it can be in the onboarding documents, it can be handing people statements of faith and having them acknowledge that. It can be including compliance with religious tenets as part of their performance reviews, attendance at seminars having to do with their religious studies and all of those kinds of things. All of these things that hopefully when we get the case are documented in some way are very, very helpful in maintaining that.
And that's why Sarah always says, these things here, go Sarah.
Right, and just to kind of follow up a little bit more, I think one thing, in addition to having those operational documents, it's always good to document everything, but it's that be consistent in applying those policies.
Amen.
You want to make sure that someone isn't being singled out. You want to apply it across the board. And that case, the Herx versus the Diocese of Fort Wayne, is an interesting one in that one of the situations there was that the policies weren't applied across the board equally. It was a case that involved a teacher who had in vitro fertilization. She had a child or was having those treatments. It was a female teacher. And eventually she was terminated, and it came out during trial. And I know Steve has talked about this yesterday when we were talking about this, so he can jump in here. But it came out that there were male teachers at the school whose wives had undergone in vitro. And so that policy of termination for not staying within the tenets of the faith was not applied to the men the way that it was applied to the female teacher. So you want to be consistent across the board, because it makes our job a little easier when it comes down to it if there's a problem. Because as we said, anybody can walk into the courthouse and file a lawsuit. So if you're prepared, you have your ducks in a row, so to speak, and you can present, look, we told them at the beginning, these were the tenets of our faith. We handed them a statement of faith. These operational documents document extremely well how we feel about our faith how our employees is that employee handbook. If you're going to have something, if a problem arises that Bob was talking about, support your position, faith-based.
So let's please review those organizational HR documents. We've also talked about the use agreements. Integrate those into your facility use agreement. I look at the church as your facility is an outreach to the community. It's a big part of your ministry, and we want to allow people to come in and use the facility, but we want to understand. And Steve, I love what you guys have done at Brotherhood here about this facility use continuum, putting this together, because everybody's saying, well, how do we protect ourselves completely? Or, can we, and so it varies, and there's different things that they can do. Maybe you can discuss those with us.
Yeah, so we're going to take a little bit of a detour, if you will, but like you said, Charlie, this is pretty important because we're talking about employment practices and religious freedom in employment, but facility use is really closely connected to these things, especially on the religious freedom front. When you think about facility use, how you're using your facilities, how you're allowing others to use your facilities, you want to be mindful of what's called being considered a place of public accommodation. Public accommodation, it's a term of art. Essentially, it has happened to some ministries in the past where they become recognized as a place of public accommodation. And that means that there's a court that's saying, you know what, you look just like a department store, a bookstore, a public park, any type of other secular activity. And if you're found to be a place of public accommodation, you lose some of those religious freedom liberties or rights to associate with people of similar viewpoints, to prohibit folks from participating who have contrary beliefs or might stifle your ability to gather and share in those views and things of that nature. So it's a very important thing. I always go back to a case out of New Jersey that involved the Ocean Grove Camp Meeting Association. And in that case, there was a same-sex couple that approached this camp meeting association. It was a religious organization, and asked if they could have their same-sex wedding in this pavilion on this boardwalk. And everyone who's been there has told me that the Ocean Grove Camp Meeting Association is this beautiful, sprawling property. They have a historic building on the property where they have religious services and things of that nature. And then they have this other section of the property that it really looks like a public park. There's a boardwalk, this large pavilion. Members of the general public frequent it. They hold weddings there, things like that. And so when they refused to allow a same-sex wedding to take place based on their sincerely held beliefs, it went to the courts, and the court actually said, listen, this part of your property looks like a public park. It's not obvious that it's part of a religious organization, that it's used for religious purposes, because there are so many different regular everyday activities happening. So we're going to carve this part of your property out, and this is going to be considered a place of public accommodation. And so you now have to allow the same-sex wedding to take place and others to use your premises. And so that's what we're talking about when we talk about facility use. So we created this continuum to say, there's a safe way to use your facilities, and there's a less safe way to use your facilities. And there's 5 categories that can put you into a safer position. Number 1 is what Charlie was already talking about, and that is having a facility use agreement, having a written document that if someone wants to use your facilities for a birthday party, a family reunion, a wedding reception, an HOA meeting, any number of different activities, you have them fill out the facility use agreement and says, this is why we want to use it. This is when we're going to use it. You can address insurance issues. But there's also a paragraph that we definitely recommend, and that provision is that the person or group, they certify or affirm that they will not use the facilities in a way that's contrary to your organization's beliefs. They will not use the facilities in a way that's contrary to your beliefs. So that's very important. And then number 2 is that you have a belief statement that lays out what your beliefs are, what your expectations are, and that it's seen by them. And then you can go through the continuum to say, okay, if we're charging a fee, where does that put us? If we're charging $2,000 for a wedding reception, that starts to look like a for-profit endeavor. And so courts might say, you know what, this is looking more like a civic center or any type of other rental facility, and it could be a place of public accommodation. If it's a general fee or at cost, that's a safer position. Who do you allow to use your facilities? Is it open and advertised to the public? Is it limited to members, attenders, folks affiliated with the organization, that type of thing? And then the final thing is something that you really don't have control over, but courts will actually consider it, and that is, what's the nature of your building or your facility itself? Does it look like a traditional religious institution, or is it a repurposed department store or storefront or repurposed warehouse? And even they'll take that into consideration. But most importantly is having the facility use agreement, having the belief statement puts you into a very safe position.
And Bob, in California, when are we prohibited from things like a belief statement? We talked a little bit about the Unruh Act.
Well, the Unruh Act applies to discrimination in business. And so the question then becomes, as Steve is pointing out, really, are you operating, is this facility part of your mission, your religious mission, or are you in the business of renting out a wedding reception hall? In which case the Unruh Act is going to apply to you, that you have to provide it, to the public in general. So the importance of the things that Steve just mentioned regarding the facilities use agreement, the statement of faith, many organizations will only rent sometimes to people that are members of their church or members of a very similar church. Those things all become extremely important. But from my standpoint too, the documentation of that is very important, because so often we get a call from a minister that says, well, we got a complaint from somebody because they wanted to use the facility, and this is a same-sex couple, and according to our theology, that's not appropriate. And I say, okay, where do you have this written down? And they don't, which that's not the end of the case, by a long shot, but it's here to explain. Two things, if we can just back up on this issue too, a couple of things. This issue has come up with me several times with regard to camps. Some of the religious camps that we represent actually get referrals from the Child Protective Services agencies in the county if they're trying to place kids with a family and they want them to send them to camp, but they're trying to help out a family and that kind of thing. And sometimes I've had, as an example, a camp say that they had received a referral and the child was dressing differently than his or her birth gender. And the camp was run, of course, by a religious organization that felt that one was supposed to act and behave and dress consistently with their birth gender. So we had to exclude that particular child. Now, I think it is very, very important how you go about doing that, because our job right from the outset is to try to avoid claims if at all possible, engage in risk management. And if you address this thing in the appropriate manner, I think you can avoid a claim entirely. I had suggested in that case that the director of the camp explained to the Child Protective Services a representative who was referring the child that it wasn't that we don't want this child here, but perhaps this environment where we're teaching our theology is not the best environment for this child. It might not be the most workable thing for this child. And I can recommend to you 2 or 3 other camps in the area that might better be able to meet that child's needs. So you're not just saying, no, absolutely, we're shutting the door on you, but rather we can refer you someplace else.
Let me give you this situation. Let's say I've got a progressive church and I'm sitting there. It used to be the parsonage. It's right adjacent to the church. And I rent to somebody and someone puts up a Make America Great Again sign. And it's a political sign and it might be, it's political. Is that something that, might be contrary to the belief statements of the church? that we could discriminate against based on a tenant in the housing situation?
Steve, I think you could probably comment on this. The first thing that would come to my mind is whether or not the church is running the risk of losing their nonprofit status by getting involved in any sort of political activities at all. I'm not a tax attorney, but that is something that I immediately always tell my clients if they're getting involved in some sort of a political issue that they need to talk to their CPA or their tax lawyer about. What are your thoughts, Steve?
Well, first of all, I think we should do a webinar on the Johnson Amendment, which prohibits religious organizations from supporting candidates or diving into politics. But it's only been enforced once, so it's an interesting issue. You know, with residential tenant situations or even commercial tenant, what we see more often than not is it's not jeopardizing tax exempt status or being recognized as a religious organization as much as it might jeopardize property tax exemptions. That'd be probably the larger risk, in that if you have for-profit endeavors, a lot of jurisdictions, they'll carve out that square footage or acreage and say, okay, this part of your property is not entitled to property tax exemption. But there are jurisdictions that if it gets to be a certain square footage or a certain percentage of your total area, they'll say you've lost your entire property exemption. And
especially in LA, we've seen that a lot.
Yeah. So that I would say would be the larger issue. The thing I'll mention, and there was a question on this, and I know that we're strapped for time, so we can't answer every question, but I think it was a very good question, and that is, you know, if you're allowing part of your facility to be used for a voting area or anything like that, a polling station, does that jeopardize your tax exempt status? And I'd go back to kind of what we talked about at one of the points earlier, and that is always explain your why. So if you can explain your why and tie your activity to your ministry, even if it does look secular in nature, if you can explain and you can document that why, that's going to provide some added protection. So you think about polling stations. Again, you have people stepping into your facilities who would not ordinarily step into a religious organization. And so this is an outreach opportunity as well. I know my church, we host various HOAs, and the reason we do that is because our pastor is there at the start of every meeting to greet them with hot coffee, cookies, and just the love of our church, because these are people who would not ordinarily step foot in a church maybe.
Okay.
Charlie,
All right. I do want to tell you guys, I'm going to tell you, I've done a great job because we're only 3 minutes over and I've got 3 attorneys on this webinar, and we're going to the second one. So we're doing great on time. Right, Bob? But go ahead.
There was just one other issue. There was a really good question that came up, and I think it's important. As far as the action plan following the Bostic case, one of the questions that popped up said, our employee manual, it was along the lines of our employee manual says we won't discriminate based on Title VII or California law and that kind of thing. I am very concerned about those things. I think your employee manual, the way we're drafting them now, should say that the employer will not discriminate on we will not discriminate in violation of any applicable federal or state laws, because clearly California law doesn't apply. And I saw one, it was a trial court opinion that is now up on appeal out of San Francisco, where the plaintiffs tried to allege that the religious employer had waived their exemption from FEHA because they included a mention of FEHA in their employee manual. So again, we got to be careful about the language in employee manuals saying that you don't discriminate is prohibited in any applicable state, federal, or local law.
Okay. All right, Bob, your favorite, Hosanna Tabor.
Hosanna Tabor.
How many times have we talked?
This is one of the greatest cases that's come down. Hosanna Tabor, for those who aren't familiar with it, let me back up and just explain a little bit. Deals with something called the ministerial exception, and the courts of appeal over many years dealing with the discipline or termination of a minister have told us over the years that the minister is the, quote, embodiment of the faith within the organization. The minister is the person that is chosen to spread the faith. Therefore, the minister, being the embodiment of faith, is the expression or the free exercise of religion. Therefore, the minister's role with the religious employer is protected by the First Amendment of the United States as the free expression, free exercise of their religion. So when we look at Hosanna Tabor, it was a case out of Michigan. It involved a lady by the name of Purich. She was an ordained deacon in the Lutheran Church. He held the title of deacon in the Lutheran Church. She was subject to discipline under their theology as a Lutheran deacon. She also taught at their Lutheran elementary school, and her teaching included math, science, spelling, all of the secular subjects, plus she taught theology, was required to take the kids to services X number of days a week. She was required to teach them to pray and all of that kind of thing. She then developed narcolepsy and went out on disability for several years. And a couple of years later, she comes back and says that I am now cured. I want to come back to work. The Lutheran school says we have already replaced you a long time ago and we don't have a job for you now. So she files suit under the Americans with Disabilities Act. The Lutheran church that owned the school defended the case, saying that she cannot bring a case because she is a minister within our organization. Therefore, her relationship with the religious employer is protected and exempt by the First Amendment, the Free Exercise Clause. The case went to the Supreme Court, and the Supreme Court agreed. And they looked at a number of different, what we would refer to as considerations. They're not necessary factors to be found, but they are considerations that the court of the U.S. Supreme Court found in the Hosanna Tabor case to be relevant. So the first thing they said is a minister doesn't necessarily have to have the title of minister, doesn't have to be the head of the religious organization, but rather is a person whose job it is to express the faith. In this particular case, the things they found important is Ms. Purich had a title reflecting religious training. She was ordained. She had a job description that provided that she was to provide religious training to the kids in the school. He also was required to take them to services and that type of thing. They also said that she doesn't, a minister, to be a minister, you don't have to be formally recognized as such, but rather we're looking at the substance of this person's work rather than the title that they might have within the organization. So in that case, they found in Hosanna Tabor that Ms. Purich did fall within the ministerial exception, and they dismissed her case. And that brings us up to our new exciting one.
I know, and
Yeah.
it's really similar, and that's what's crazy about it. So I'm sorry, go ahead, Steve.
No, and you're right that they're similar. The issue is that back in 2012, when this case was decided, Hosanna Tabor, is I don't think either side was really happy, either side of the issue, because the court was intentionally vague. That basically did not lay out any ground rules or framework for determining when someone is a ministerial employee or when the ministerial exception applies. And so what we have seen since 2012 is this attempt to erode the Supreme Court's decision in Hosanna Tabor to say, well, they're not a ministerial employee, or clearly they're not a ministerial employee. And so you had these two cases, both of them coming out of California, in Our Lady of Guadalupe School v. Morrissey Baru and St. James School v. Beale. And you're exactly right, Charlie, that these cases are very similar with some very key distinctions, though. So just to kind of give you a little bit of the background, I'm going to talk about the cases together. But with Morrissey Baru, she was a teacher at Our Lady, and she was hired as a teacher in an older age, and eventually she was dropped down to part-time, and then from there, she was then replaced altogether with a younger teacher. And she claimed that she was discriminated against based on her age. They basically terminated her contract because she was too old. That was her allegation. With Beal, Beal actually was diagnosed with breast cancer, had to go on an extended leave to get radiation, chemotherapy, and surgery. And when she was ready to come back, the school said, you know, very similar to Hosanna Tabor, sorry, we've already filled your position. We're not going to renew your contract. And so she alleged that she was discriminated based on her disability, having had breast cancer and not being able to work. And it was a very interesting case because at the trial court level, you saw the courts, the district courts, kind of go through this and say, no, ministerial exception applies. We're going to rely on Hosanna Tabor. And then it went up to appeal, and the appellate court, which is the Ninth Circuit out of California, they really did this deep dive analysis to what the teachers were doing with their teaching duties. And one of the key distinctions made is that these were Catholic schools, and neither Morrissey, Baru, or Beal were practicing Catholics. So they weren't required to be practicing Catholics. They weren't ordained in any way or called teachers, which is something that the Lutheran Church in Hosanna Tabor did, is they said, you are a called teacher, so you are ordained. And that was not the case here. So really anyone with a teaching certificate and a degree could be a teacher at these schools. And then they looked at in the appellate court and they said, well, okay, so when you started, you only had a half day of training on religious studies. You were only required to do 30 minutes of religious instruction 4 days a week. And even then you were only teaching it directly out of a workbook, not from your own beliefs or training. And then they said, you're only allowed to attend, or there are prayers that you have to participate in twice a day, but those are student-led prayers. So you as a teacher, you're not leading the prayers, and you only have to attend but not participate in Mass once a month. And so that's kind of how the appellate courts framed this. So they said, well, you really don't have enough contacts or enough duties to be considered a ministerial employee. And it went up to the Supreme Court because they held that the ministerial exception did not apply. And the Supreme Court really looked at the same exact thing. And they said, well, first of all, we don't want to get into the business of kind of evaluating the degree in which someone is a ministerial employee. That's getting very in depth with what somebody's doing. And they pointed to everything that the appellate court said and said, well, that seems like a lot of context. But they also went a step further, what was kind of ignored by the appellate court, and they said, well, wait a second. When they were hired, the employee handbook said that they're expected to follow the beliefs and to instruct in the beliefs. They signed statements with their teaching contract that required them to affirm the beliefs and affirm to kind of follow those beliefs while they were teachers and all of those things. And with that, the courts basically said they are ministerial employees. And Justice Alito wrote the majority opinion, and he had a really strong concurring opinion back in Hosanna Tabor as well. But he said, when a school with a religious mission entrusts the teacher with the responsibility of educating and forming students in the faith, judicial intervention into disputes between the school and the teacher threatens the school's independence in a way that the First Amendment does not allow. So it basically affirmed Hosanna Tabor and really strengthened it, because it's saying it is not the court's place to entangle itself in interpreting who a ministerial employee is. We're going to give, as a court, we're going to give deference to the ministry to determine who they have identified and hired as ministerial employees. And the only way to do that assessment is by looking at what they do, not what's in a title, not anything like that. It's what they actually do. And that was important. And obviously it has broad reaching implications far beyond just a school in several different ways. And I'll let Sarah speak to that.
Well, and I think kind of the key words that I like to take out of that is the they performed vital religious duties. And I think if you kind of have that in your head all along, it keeps the continuance going of the purpose of these people that are being designated as ministers. They're furthering the religious mission. And these employees were educating and forming the students in the faith, even if it was, as Steve mentioned, the trial court had said, well, you were just using the handbooks they gave you, but that's coming from the school and the church. So it is in furtherance of the religion. And again, it was in these employment agreements. And so it's kind of interesting how this ministerial exception, it continues on with just the exemption that we talked about with Title VII. You want to just keep continuing in making sure that the designation is there, that it is in furtherance of religion and your mission and the purpose of, in this case, these schools. And another thing that was also very important is that while weaving it into the performance reviews, their work and their performance was evaluated on the way that they were fulfilling those responsibilities. And both of these women, the schools said, you know, their performance was not kind of up to par, so to speak. And so they were not given additional contracts. And that would transition over into a non-school setting. If you can weave that into the work performance, the expectations that you need to set for your employees, and it kind of circles back, like I said, to these vital religious duties. I think that's kind of your catchphrase that you just really want to keep in mind going forward in order to be able to assert this ministerial exception, because then it kind of takes priority over these claims of the age discrimination or the ADA claims that these teachers were making. They didn't even get to that analysis because it was held that these were ministers and looking at all the factors that contributed to them furthering the religion.
So, Sarah, let me ask you, is age discrimination allowed for religious employers?
Well, I don't think it's that simple. And like I said, I think that's something the employee is going to allege, that they'll claim it's a pretext. But if you look at these cases, the analysis, the court says, okay, I know you are acknowledging that the church's response or the school's response is that there's a ministerial exception. And so they looked at that first, and when they found that there was the ministerial exception, they don't get to the age discrimination portion of the claim.
But if you've got a church and you've got a youth pastor, and the youth pastor, you know, started when he was 22 and all of a sudden he's 72, can the church board look at him and say, you know what, you do not relate to these kids anymore. You do not, you don't know what Twitter or TikTok is, and you're trying to get kids to connect on MySpace or whatever it is, and you've totally disconnected. You're old, get out. I mean, is that something that a church can do?
I think probably you should leave out the "you're old, get out," but everything you just said goes to their ability to perform vital religious duties. If they are out of touch, maybe it's because of his age, but because they're out of touch, they are unable to perform vital religious duties kind of by, you know, today's more modern standards, you know, rather than just a book, you need to be out there on Twitter sending out the message, that kind of thing. So
okay,
just spin it that way. Spin's probably not the right word, but you look at it that way. And again, then it doesn't become this, it is an age thing. They're not in furtherance of the mission.
Because whenever we receive an employment practices liability claim, if they're over a certain age, they're going to say they always throw in age discrimination. And really what I'm asking, is that something that's going to be able to be thrown out right away based on Morrissey?
And I
don't think so.
I think so, because like I said, okay, you look at that first before they get to the age discrimination claim. What the employee is going to want to do, though, is try to say, well, they're claiming this ministerial exception as a pretext. It really was about my age. And so refraining from saying you are too old, that if you tell an employee you are too old, that's going to go towards the pretext. you're you're giving them the ammunition to shoot down any ministerial exception.
Yeah, I think, and what Sarah's saying is the importance of the ministerial exception is that courts are not going to second guess ministries. So if a ministry has a lawful explanation and reason for having terminated someone, they're not going to dive beyond that or behind that and say that, well, if it was a pretext, then we're going to do a deeper dive investigation. Because that's exactly what the issue was in Morrissey Baru, is she claimed age discrimination, and the ministry said she was not fulfilling her duties up to our standards as a ministerial teacher. And because they had that plausible, rational explanation, the court said, we're not analyzing age discrimination. Dismissed.
Right. And because the court also said, we're not going to get into the government aspect, the governance of the church. We're leaving that to the church.
Yeah. Okay. Bob, I didn't know if you had anything on this.
Sure.
We
we often get a question, Charlie, and I'm sure you have too, as we started doing the seminars on Who's on a Paper initially, why don't we simply give everybody a job title that says that their job is a minister? I'm the receptionist minister, I'm the IT minister, and so on and so forth. If one of the things that you can take away from both Hosanna Tabor and the new case is that the court is looking at the substance of what this person is really doing, and is the job of this person part of proclaiming their faith, either to the current congregation or to new people that they might bring into the organization. So the court is really looking at a bunch of different factors or activities that they're engaged in, and they're asking, is this substantially ministerial in nature? Just giving somebody a job title doesn't create much of a substance. I think it's one of the reasons why the court originally in Hosanna Tabor and in Our Lady and the St. James case, they still haven't come up with a defined list of rules, a specific list that you need to meet, a checkoff list. And I think that's going to continue to frustrate courts for some years to come. But the Supreme Court was very clear in why they haven't done that. And the reason that they haven't done that is because all kinds of different religious organizations are different. Their theology is different. How they operate is different. Who teaches, who expresses the religion, it varies from organization to organization. So one of the comments, I believe in the Our Lady case, was that they couldn't possibly do that without running the risk of disenfranchising some smaller, less sophisticated religious organization because they didn't have all of the ordination procedures in place and discipline for ordained people in place. And the court didn't want to in some way say that this organization, although they are, in my terms, a little bit less structured than some of the other larger organizations, that their religion wasn't just as important to someone, to them as a more structured organization is to their congregation. So when we're looking at Hosanna Tabor versus these two new cases, Our Lady and St. James, it's really a matter of degree. All we saw is very much similar activities between Hosanna Tabor and the Our Lady and the St. James case. But in the later two cases, the degree to which these people were given titles or required to have religious training and so forth was less. It wasn't that it wasn't there, it was just less in the Hosanna Tabor case. And the court says, we're not concerned about that. Just because one religious organization has less structure or fewer requirements than were in place in the Hosanna Tabor case, that's not important. We're looking at the substance of, is this person's role important in teaching and carrying on the faith of that organization? Those are the most important things. And as Sarah was speaking a few minutes ago, you had a list up of a number of different things that were important in the Our Lady in St. James. And all of those things, again, I get back to these are evidentiary based. Those things were all documented in those different organizations, which is certainly helpful in establishing the religious mission of the organization.
So I think that we can all know clear expectations. We need to document it best that we can, and talking about how these are all vital religious duties and furtherance of the ministry. Is that right?
Yes.
Absolutely.
Okay.
I think
All right.
all those factors you're looking at, it's both quantity and quality. It's not one or the other. They're going to consider both.
Yeah.
And what's great is these are both California. This is a California claim, and I think it has really helped out a lot of ministries here in California to discuss this. Okay, now Steve, tell us what is on the horizon.
Yeah, well, I think a number of things. I'll let probably Bob mention more on the employment side. I just wanted to, before we dive into kind of what's coming down the pike, just something else that we didn't really touch on, and that is really government funding, benefits, public benefit, things like that, because there is some good news that came out, including Our Lady. But there were a few cases. Trinity Lutheran is one, and a case called Espinoza that the Supreme Court has ruled on in the last 3 years, and Espinoza was this year. But basically what those cases said is that a religious organization cannot be excluded from grant programs, from other public benefit programs, simply because it's a religious organization. Trinity Lutheran had a Lutheran church that wanted to get a grant from the state of Missouri to get shredded tires for their playground. And the state of Missouri excluded them, saying, sorry, our funds can't go to religious organizations. And there's this thing called the Blaine Amendments that a lot of states have, I think 26 states, that basically say separation of church and state, so no state dollars can go to religious organizations. And the Supreme Court has emphatically, in these two cases, held that is unconstitutional. You cannot exclude someone to an otherwise publicly available benefit simply because they're a religious organization. And so that's huge. So, you think in terms of FEMA, National Disaster Relief. FEMA has changed their position and said, you know what, now religious organizations qualify for disaster relief funding. We saw with PPP under the CARES Act that the Small Business Administration for the first time said religious institutions qualify for this funding. And we're going to see that more and more. I hear a lot of ministries say, we don't accept any government dollars because we know that there's always strings attached. Well, these Supreme Court cases essentially say, be careful. I don't think the government can attach those strings to a religious organization. And so that's some good news that's going to be very important in the coming years for religious organizations.
Okay, well, I appreciate everybody being here today. We're right on time at 11 o'clock. I do want to tell you, we can, I don't know why yours spun. Did you see that, Bob? Do you see the way yours spin? I was getting fancy. Let's do it again. Oh my gosh. Sarah's going to get mad at that one. I don't know, Sarah. We'll try to get yours spin next time too. Again, I got to tell you, Steve and what he's done at Brotherhood, and especially the legal assistance service that you guys provide, is a great resource. You've got a whole section there on a lot of these issues that I encourage people to, kind of go down that rabbit hole, just because there are tremendous resources that you put together, Stephen. We appreciate that very much. Sarah and Bob, I rely on you guys on like a daily basis as churches are calling and they're saying, well, I talked to Sarah, I talked to Bob. Church is calling up and saying that. So anyway, I appreciate you. I know that ministries appreciate you guys a lot as well. And so thank you very much for the time that you've put into putting this together. Everybody, we're going to be sending out something today, probably this evening. That'll be a recording of this, the slide deck, and pointing you to some of the specific resources that were mentioned. Okay, so thank you all very much, and I appreciate the time. All right.
Thank you,
Charlie.
Thank you.
Okay. All right. Thanks. Bye-bye.
Bye-bye.
Oh, I didn't end it. I just ended the PowerPoint. There we go. All right. See ya. All right. Bye-bye.